Mr. P. Chidambaram.
Sir, I'm grateful to you for giving me a few minutes to speak on the subject. I know that the subject has been extensively covered by my colleague, but I wish to make just a few points, not with the intent to oppose this bill, but to ask the government whether our understanding of what they are doing is right, or do they have a different understanding, which would be the correct understanding. So firstly, sir, let me take the New Delhi International Arbitration Centre here. The intent is good. The intent to take over the existing society is good. The intent to promote arbitration, promote research, maintain a panel of accredited arbitrators, all that is good. But who is going to run the centre? The centre consists of a chairperson appointed by the central government in consultation with the Chief Justice. Full-time or part-time members, two eminent persons appointed by the central government with no consultation with anyone. One representative of a recognized body of commerce chosen by the central government. Secretary, Department of Legal Affairs, which is the central government. Financial advisor, which is the central government. This is a Sarkari Management Committee.
Sarkari Center. Sarkari Center. Arbitration Center.
The center has great objectives, but the appointment power is entirely controlled by the central government. This will inspire no confidence among litigants.
Internationally.
I hope nobody says that I have a conflict of interest. Speaking from my experience as a legal practitioner, this will inspire no confidence at all. It is doubly so in India because half the major arbitrations, the government is a party.
Exactly.
The claims are against the government. And therefore, while the intention of the bill is good to take over the existing centre and constitute, as a rejuvenated New Delhi International Arbitration Centre, it should not be construed as the Government of India's Capital International Arbitration Centre. It will be seen as a Sarkari centre, and I'm afraid the intention with which this centre is being established will be lost. One other point, maybe a minor point, but I think it is important. The section says that the centre may constitute such committees as may be considered necessary to administer various aspects of its functions. This is section 19. Centre means the chairman and the full-time member and the part-time member. The composition and functions of the committee shall be prescribed. Now, who will prescribe? The central government will prescribe the composition and functions of the committee.
Yes.
If you are appointing somebody as eminent as a judge of the Supreme Court or a judge of the High Court, an eminent jurist, to form the committee, why can't that management committee decide the composition and functions of the subcommittees? So I think, sir, these two grave defects must be corrected. The central government must not appoint the chairman and the members. The central government should constitute a collegium and then leave it to the collegium to make these appointments. And whatever the central government wants to do under these two sections must be done by a collegium. It will be in the larger interest of this country. It will inspire confidence if the central government maintains as much distance as possible from this centre. On the contrary, what this bill does is bring the central government so close to the centre, it will be seen as a Sarkari arbitration centre. So in the other bill, an attempt to clean up some provisions of the current Arbitration and Conciliation Act, which we welcome. The power to appoint arbitrators under Section 11 was now with the Supreme Court of India and the High Courts. That power is now being given to an arbitral institution recognized by the Supreme Court and by the High Court. I'm not sure this is a very satisfactory resolution, but if the intention is to avoid applications under Section 11 to the Supreme Court and to the High Court and leave it to the parties to apply to the arbitral institution, I have no quarrel, but one has to wait to see which are the institutions that will be recognized as the arbitral institutions. Unless truly independent, truly professional institutions of arbitration are recognized as the arbitral institutions under this Act, to take the power away from the Supreme Court and the High Courts and vest in those arbitral institutions might backfire. But I'm not trying to be a pessimist. I sincerely hope that the Supreme Court and the High Courts will designate only suitable institutions, highly qualified institutions, highly reputed institutions as the arbitral institutions. There's another section where I think the government is trying to clean up a matter, but I wish the minister clarifies, because the minister's statement on the floor of the House will be a guide to interpretation should a challenge arise. Sir, as the minister certainly knows, and many in this House will know, the Arbitration and Conciliation Act was amended in 2015, and the amending Act had Section 26.
Yes.
And Section 26 made a distinction between arbitral proceedings commenced before the amending Act came into force, that is 23/10/2015, and the date after the amending Act came into force. The question was, what is the impact of the Section 26 upon Section 36 regarding whether there will be an automatic stay of the award when an award is challenged in the High Court. I'm sorry, I'm getting into technical language, but I'll try to simplify it. When an award is challenged before a court under Section 36, the earlier provision was there was an automatic stay. But the amendment made in 2015 did away with automatic stay. But by virtue of Section 26 of the amending Act, a question arose whether a distinction is deliberately sought to be made between proceedings commenced before the amending Act and proceedings commenced after the amending Act. 10 high courts took a certain view, a few high courts took a different view. It took 3 years for the Supreme Court to finally settle the law, and I think they overruled 10 high courts and affirmed the remaining high courts. Now what this present Act does is to omit that famous Section 26, but omitted from 23/10/2015. Now, as far as my very learned friend Abhishek Singhi and I are able to understand, the idea is that as if 26 was never made part of the statute book.
Exactly.
If Section 26 was as if never made part of the statute book, is our understanding correct that in all challenges to all awards before a high court, whether the arbitral proceedings commenced before or after that famous date, in all matters there is no automatic stay? If that is the provision, we welcome it. It cleans up, it should have been cleaned up. Of course, it gave a lot of pleasure for us to argue these cases before the courts, but it took us 3 years to clarify that matter. This should have been done much earlier. The original 26 was very clumsy in 2015. Whoever is responsible, it doesn't really matter. But if your attempt is to clean it up, we welcome that. But please make the statement in the House so that let the record show in all proceedings where an arbitral award is challenged in a high court, there is no automatic stay unless the court grants a specific stay. Sir, I think that's all. Sir, the only other point is, while this act sets up, the amending act sets up a council of arbitration to promote arbitration, the New Delhi Act also has similar functions by promoting arbitration, promoting research on arbitration. There is some overlap. I'm not worried about overlap. India is a very large country. There's no harm if there's overlap between the functions that will be performed by the New Delhi Arbitration Centre and the functions that will be performed by the Council of Arbitration. We must promote arbitration. Final point. Why is arbitration not so popular in India? This is the final point. And I think it's an important point. Arbitrations are not popular in India because the government is a relentless litigant. It litigates at every stage. There are cases where 3 eminent retired engineers who have served the railway or other departments of government are arbitrators. They give a unanimous award and the government challenges it. They challenge it before the High Court, then they challenge it before a division bench, they challenge it before the Supreme Court. So the government is simply a relentless litigant which fights every case to the last point. The reason is very simple. We all know this. No officer wants to take the responsibility to say, let's not file an appeal in this case. What he gets is an opinion from the law officer who will say, fit case for appeal, 4 words, fit case for appeal, and every officer will sign that. Unfortunately, the only one, if he has the courage to overrule that and say no appeal should be filed, is the minister. No officer will say let an appeal not be filed. Now, unfortunately, if a minister overrules his officers, immediately you point a finger at the minister and say, aha, something is wrong here, something is cooking here. All these officers wanted to file an appeal and the minister is overruled. So what does the poor minister do? The minister says, fine, if all the officers have said, let's file an appeal, let's file an appeal. The result is litigation never ends in this country. Now, sir, the Sri Krishna Committee made a salutary recommendation. The Sri Krishna Committee said, create specialist arbitration benches before various courts. The bill is silent on that. Second, it said, if an award is challenged, the judgment debtor must mandatorily deposit 75% of the sum award. If this recommendation is accepted, the losing side would have to deposit 75% of the award. Now, in the meanwhile, the Niti Aayog issued a circular saying, accepting this recommendation, 75% of the amount should be deposited. And then the Niti Aayog issued a circular, and I congratulate the Prime Minister for that. The Niti Aayog said this was considered at the highest level. The Prime Minister convened a meeting, and the Prime Minister said this is how awards must be respected, 75% must be deposited. The Niti Aayog circular was sent to all the ministries. I request ministers, honorable ministers, to please check with their secretaries, sent to all the ministries, and said this is a decision taken at the highest level by a meeting chaired by the Prime Minister, and therefore everybody must abide by it. Every ministry opposed that circular. No ministry was willing to implement that circular. They found reason A, reason B to say this does not apply to us. This only applies to construction contracts. This only applies to highway contracts. All kinds of excuses were found to scuttle that circular. The net result is that circular is not applicable today, which means a decision taken by the Honorable Prime Minister, and I once again commend the Prime Minister for taking that decision. A decision taken by the Honorable Prime Minister has been observed more in the breach, has been honored more in the breach than in the observance. I want the Honourable Minister to say, we stand by what the Prime Minister decided. If the Niti Aayog circular has been treated with scant respect by ministries in litigation, we will reiterate the circular by ensuring that not the Niti Aayog, by that the Department of Personnel and Administrative Reforms or the Ministry of Finance or the Ministry of Law will issue a circular reiterating the wholesome decision taken by the Honourable Prime Minister that when an award is challenged, you must deposit 75% of the amount of the award so that litigation can be quickened and shortened. So these are my comments. We support this bill, but we urge the Honourable Minister to take note of what we have observed. Thank you.
Thank you, Mr. Chidambaram.